status. However, I have get couple of refusal from different clients. They came to me and they are saying that their parents get a family permit under EU settlement scheme or previously under EU law, and then they win the appeal, they get it. And now when they apply for pre-settled status, Home Office refuse the pre-settled status of their parents on the ground that the applicant failed to prove the dependency. But what does the immigration rules say? Well, immigration rules say that is if the parents get limited leave to enter or get a family permit under EU law under Appendix EU, any subsequent application they don't need to prove dependency. That means if a parents get pre-settled status under EU law under Appendix EU, then immigration rules Appendix EU say that they don't need to prove dependency again if they made any application for pre-settled status or settled status in future under Appendix EU. Now, where you'll get the law, if you look into the Appendix EU definition Annex 1 dependent parent, it's clearly say in the definition, if you look at the paragraph C, that is said that those parents who has already get limited leave to enter under this appendix, they doesn't need to prove dependency. If you look into EU settlement scheme policy guidelines, page 124, and where the paragraph started with dependency, it clearly said that the parents who has got family permit or limited leave to enter, that doesn't need to prove dependency any subsequent application, whether pre-settled status or settled status. Viewers, I'll speak today a couple of issues regarding EU law update. Please bear with me. I will come after a short break. My name is Suhail Ahmed. I'm a solicitor. If you have any question, please feel free to make a comment on my below my live video. I'll try to give you an answer, but mainly today I'll give you some update on EU law. Although we are out of EU, but the door has not closed yet. Still, EU citizen can invite their family member to come to the UK. But mainly I'll speak about today dependency, because Home Office is still refusing a lot of application for parents. Some people already get family permit, and when they applied from inside the UK for pre-settled status, unfortunately and very unreasonably, Home Office refused their application on the ground that they failed to dependency. I have already give some idea that those parents who has a get family permit, they don't need to prove dependency for pre-settled status, and if the Home Office reviews this is unlawful. Now, the other update I'll give you about the extended family member. Now, well, the main point is that extended family member will not able to get benefit from the EU settlement scheme. This is we know. However, more specifically, upper tribunal in the case of Batul and others versus SSHT, where the court upper tribunal has said yes, those who hasn't got any family permit under EU or registration, well, and a residence document under EU law, they will not get any advantage, or they will not able to obtain they will not obtain EU settlement scheme family permit or pre-settled status or settled status. In any way, although the court has confirmed in recently last week, however, this immigration rules already stated, and I have gave many update about it, because under immigration rules Appendix EU, it said any family member, any extended family member, if they want to apply for pre-settled status, the eligibility requirement is, one of the condition is they must have a EU residency permit, EU residence document, that is EU family permit. Now, EU family permit only available under EU regulation. Under EU settlement scheme, there were no provision for extended family member. That means those extended family member who has a residence permit under EU law, they will be able to get pre-settled status or settled status under EU settlement scheme. Those who hasn't got any residence permit or EU family permit under EU laws, they will not get any pre-settled status. They are not eligible to apply for pre-settled status or settled status. Now, what I have noticed is lack of appropriate advice. Many people approach to many stranger, so-called immigration. Some people is they're not qualified, they don't have knowledge about EU law, so they manage to get either a brother or a sister or some relatives. They are applying as an extended family member under EU settlement scheme, and later the Home Office refused because the immigration rules appendix EU say that if you are a extended family member or anyone who want to apply under EU settlement scheme, they must have a residency document, EU residence document, EU family permit, or EU residence document under EU law. Now, extended family doesn't have that. That means they're not eligible. And once they refused, they go to the they go to the appeal. They do appeal. They pay a lot of money, and in the court, in the tribunal, the Home Office only bring attention of the only one simple one law, only simple 1 point of law, that is the eligibility requirement, and judge is satisfied that this person is not eligible because he doesn't have EU residency documentation, which is resident card or EU family permit. So many extended family are made an application under EU settlement scheme, those who has no residency document. And if the Home Office refused, most probably 100% there is a chance that they will refuse unless Home Office do any mistake. So if they do refuse your application, my advice is not necessary to do appeal, to spend money on appeal, because there is no chance that there is unless there is a miracle. But according to immigration rules, you are not eligible. However, if you do have a residency document, for example, many extended family made an application under EU law, and the Home Office refused their EU family permit on dependency or some other grounds. Subsequently, they do appeal, and the appeal was successful. And Home Office said, well, there is no more EU law, and under EU settlement scheme, you are not eligible for EU family permit. Therefore, we are not going to issue family permit. But anyway, currently the Home Office position has changed. Now they are giving them a special concession, and the extended family member, those who own the appeal or will win the appeal, they are getting family permit under EU settlement scheme. So you do have a documentation under EU law. In that case, although you are extended family member, still you will get pre-settled status. So don't misunderstand extended family member. Okay, so extended family are those who has pre-settled status, leave to enter, either under EU law or under EU settlement scheme for by special concession. You still eligible for pre-settled status or settled status. Those extended family member who hasn't got any documentation under EU law or under EU settlement scheme by special concession, you are not eligible. That was immigration rules said, and furthermore, it was confirmed by the upper tribunal last week. So I hope you understand. Now, next point I want to discuss about family members, non-EU family member. Okay, so many people still is confused about whether they can invite their family member to come to the UK. Well, still the EU settlement scheme allow to bring a certain circumstance, which I gave you already an update last week. You can bring them. Now, the problem of the non-EU citizen is facing is when they apply, when for example when they apply subsequent application for settled status, or once the EU family member get EU family permit and they are in the UK, they made an application under EU settlement scheme for pre-settled status. Some circumstance, Home Office refused, for example, on dependency ground. Now, one thing you need to understand that immigration, especially for parents, doesn't need to be dependent. Some circumstances, children doesn't need to be dependent, and up to 21. So there is some loophole issue, and I think if Home Office refused your pre-settled application on the ground of dependency or relationship, you should immediately seek legal advice, because from my experience, I see in London especially many people making pre-settled status application from a layperson who has no legal qualification, lack of knowledge regarding immigration rules, case law, EU DOL agreement, EU settlement scheme. They are making this application by charging £100, but it is very important to this is some people's life. So my advice will be, if you want to make an application and if you are confused, although this application process is very easy, you can make an application by using the EU exit ID. However, sometimes it is very complex in terms of when, especially when you are a family member. So my advice will be, if you are a family member and if you want to make an application, it is wise to go at least to seek some legal advice from a qualified person, from a solicitor or advisor or a counsel who is who you can afford, and then make an application. Because once the Home Office refused, you are in trouble, and then you need to appeal. Excuse me. So sometimes it's difficult to convince the judge to win the appeal. So it is better to make appropriate appeal with valid documentation, so that you can overcome and not face any issue in future. So this is European law, and the next update I will give you about abolition of police registration. Now, those who are familiar with this, there is a provision when you submit application in the UK, there is a requirement that you might or you maybe need to necessary to register with the local police, and you need to report it sometime to the police station. So this was a requirement. However, last week the Met Police and the Home Office update that they are going to abolish this police registration requirement for any non-EU national, as now in non-EU national as well. So that was, I think it's not necessary to continue anyway this, although there is a provision for police registration, but I didn't find anyone yet that someone registered with the local police and they're going to report it to the police station. Anyway, so this is the update for today. Mainly I focus on EU law, and I also update about appeal as well. I think a couple of weeks before. If you want to bring your parents, still you have a chance to make an application, because as soon as you can prove that this your parents is dependent, and dependency means there are a couple of circumstances, but mainly financial dependency. So if your parents is dependent on you financially, you can still invite them. You need to provide evidence to the Home Office. Now, there are some difficulty where the applicant face is mainly, especially for the client. Also, when they send money, that they gave it cash to the money transfer agency, and they give a money receipt, and their parent receive it cash from back home. I think this is not right. So if you want to make an application, you have up to 2025. You should send this money through a bank. So you should transfer the money from your bank or by your card to the money transfer agency and send this money to your parents' bank account. So when you make the application, you can provide your bank statement the money receipt, and your parents' bank statement. So all these document is proof of financial which is called dependency. So and then if you provide all these documents, 6-month bank statements, 6-month money receipts, and then the caseworker should satisfy, because there are requirement for 6 months, although home office always expect more than 6 months, and I always suggest if you have these documents and provide them more than 6 months. Now also it is advisable, although it is not a requirement, but from based on my experience, home office now expect that the financial circumstance of your parents in back home, that is whether your parents need this financial help assistance from you. And also it is very important is the money what you send to them, what they use for. So whether they use it to saving or they use to buy property, that is very important. According to the immigration rules, according to the decision of Supreme Court, according to the decision of European Court of Justice (ECJ), so the money what you will send, they must use this money for their essential needs. So this is very important point. Now, because the laws that ECJ cases said, many cases, Rise, Lime, this is the lead. These two cases are leading cases, and in recently Rahman, and also Manika, these UK Supreme Court cases. So these all cases said the dependency, whatever money is that the applicant is dependent on EU nationals for their essential needs. So the essential needs means for their living cost, for the food, accommodation, medicine. So this is important to understand. So when you submit the application, also if you have any evidence of their financial situation the back home, you can provide affidavit, or you can send some statement from the applicant that the money what they receive they use for their essential needs. This is all about today about European law. There are a couple of updates about high potential visa and some other. I'll try to give this weekend. And thank you for ever watch my video live from YouTube, Facebook, from different social media platform. Keep watching and hope you will have a nice weekend. Take care, everyone.